Hello everybody, it's George from Ireland. So I'm back to the English Law Channel. So I've been looking at proprietary estoppel and the various remedies that can be granted here. So let's go through the case law. There's Sledmore and Dalby. Yeah, am I blocking out that light? Okay, 1996. So this went all the way to the Court of Appeal, and it found that even though equity had arisen for the respondent, that's like the defendant in today's terminology, it wasn't equitable to defeat it because of the benefits that the respondent had enjoyed for many years and the parties' situations at the time that the action was moved. So Dalby could have an estoppel interest, but he was given nothing. Okay, so he's representation is made, he sustained some detriment, but actually he's got so much benefit that that detriment is cancelled out. So Gillett and Holt, 2001, and this is an intriguing one because of the balance of the expectation interest and the detriment that the court decided was the right remedy. So here the defendant had promised to leave most of his property to Mr. Gillett. I think it's Gillett, not Gillett. And he'd written his will. The testator, that's Holt, had then changed his mind, and he wrote Gillett out of his will, as he was entitled to do. But the claim in proprietary estoppel was upheld. The Court of Appeal threw out the idea that there needed to be double assurance, a second promise where the defendant says that he would never change his will. It was a second promise that the defendant it was sufficient that the defendant had behaved in a way that went against conscience by breaking his promise when the claimant had, to the defendant's knowledge, relied to his detriment on that promise. So Yaxley and Gotts, 2000, another important case, went to the Court of Appeal. And there was agreement about land, and the agreement was found to be a nullity because it wasn't formal enough. It didn't observe the statutorily required formalities. So the doctrine of proprietary estoppel nevertheless could step in, and it obliged one of the parties to effectuate his promise, which was being made under the agreement. Banner and Luff Developments 2000 is a similar case. So look at Hunt and Soddy 2007. Here there been a provisional agreement that one beneficial tenant in common, H, would give her beneficial interest to another, S. Proprietary estoppel wouldn't work because the agreement had not been acted on by either party in good time, no one had taken action to his detriment, therefore it wouldn't go against conscience for H to change her mind, especially bearing in mind the major change in her situation since the provisional agreement, so she was entitled to break a promise and no consequences flowed. Okay, Holman and House, 2007. Here there was a married couple, they divorced, then they bought a property hoping that they could get back together. Anyway, they both paid some money towards purchasing this property, but the legal title was put into the name of the husband only, the former husband, I should say. He then left the house, but his ex-wife continued residing there. So then there was an application for an order to determine the beneficial shares. The ex-husband wanted an order for sale, and the court said that the promises he'd made that the ex-wife could live there for as long as she wanted must be honoured. So there have been detrimental reliance by the ex-wife. Therefore, the requirements of proprietary estoppel were fulfilled. So to satisfy this equity, there could be no order for sale unless the wife agreed. James and Thomas, 2007. Here, there wasn't enough evidence of a common intention that J would have a beneficial interest in the property, and the promises made by T to J were so imprecise as to how much of beneficial interest J could get that no constructive trust was created, nor was there one through proprietary estoppel. The trust had shared the property for 15 years, but it was in T's name alone. So J had assisted T with his business, and they had renovated the house together. So the promises were found to be too vague, and therefore the renovations benefited both parties. So and J would provide for T, J would be provided for when T died. So Pole and Benny, 2006. The appellant was Pole, and he'd looked after Benny's cousin. The cousin's called H, and improved the houses for their use after H was so old he couldn't care for himself, and given him the keys to the property. H had promised the properties to Powell on his death, but he died without having made a will and testament. So the rules of intestacy could have kicked in. But the court found there was not a strong causal relationship between the promise and the work done by Pole to receive the properties to satisfy the equity. So even though Pole had incurred some expense in renovating the properties, he hadn't been obliged to do so by age. So the case showed there was non-bargain proprietary estoppel. Jennings and Rice was applicable here. To transfer the properties to Pole would have been disproportionate to the detriment that Pole had sustained. The judges therefore awarded to £20,000, and the court said that's all you're getting. So look at Cobb and Yeoman's Row Management Limited, quite a well-known case from 2008, when house prices in London were shooting up. So this went to the House of Lords, and the Supreme Court as such didn't exist back then. So the law lords in the House of Lords looked at this one, and they said there are some exceptions to Section 2 of the Law Property Miscellaneous Provisions Act 1989. But these are narrower than was previously thought. So a property developer had made an oral agreement with someone to buy a property, and that person spent a lot of money gaining planning permission. The owner then decided he didn't want to buy on the terms they'd already agreed into and sign a contract. The House of Lords overturned the decision of the Court of Appeal. The House of Lords found the developer wasn't going to get any remedy on proprietary estoppel, nor indeed was a constructive trust. He was only going to be compensated on a quantum meruit basis. That's Latin for as much as he deserves, for his services in attaining planning permission. Because neither party had considered the agreement to be legally binding, the owner could not be stopped from asserting his Section 2 rights to show that the agreement was unenforceable. It was a gentleman's agreement, and it was too imprecise to make a contract. The lower courts had been over-enthusiastic about proprietary estoppel. Another thing is, these were both businesses. Businesses can look after themselves. The courts will intervene to protect consumers much more than they will commercial enterprises. So then let's look at Thorner and Major 2009. In this case, there was a grumpy and laconic farmer named Peter. Now, he died without having made a will. He had made a will, but he'd revoked his will. So he died intestate. So most of his will went to David, the son of his cousin. Now, this would have given the farm to David. The will had been changed, a will had been scrapped, no will made, because Peter had fallen out with one of the legatees. And he was going to give a sum of money to him initially, but he decided he wasn't going to give this person a penny. And the only way which David could prove he had a title to the farm was showing that proprietary estoppel, because on intestacy, the farm would now go to Peter's closer kin. So David had helped Peter on the farm for about 30 years. And he wasn't paid a penny for that. So Peter didn't say to David he would leave the property to him after his death. David said, well, there are all sorts of hints, and the crucial bit here was when it was said he was given a bonus notice about 2 life policies from Prudential, and Peter said, that's for my death duties. So the judge said this was a seminal moment, because David's hope of inheriting the property had turned into an expectation of inheriting the property. Thereafter, there were a number of remarks made by Peter, which David said could only be made to a person who was going to inherit the farm. So Lord Justice Lloyd gave the judgment. The Court of Appeal overturned the decision of the lower court because for estoppel to succeed in these cases, the representation had to be clear and indubitable, and it couldn't be just hints. But the case was then appealed all the way to the House of Lords, who overturned the ruling of the Court of Appeal, and they said it had been wrong to reject the High Court's decision. The trial judge was in the best position to analyse the parties' behaviour and to look at the evidentiary basis for proprietary estoppel. So if proprietary estoppel is going to be found, it's the case that an insurance must be clear enough and must relate to some particular property. It can't be property in general. We've got to know which property we're talking about. The dead man of the claimant realised the property was going to be the farm, and the situation it was when the man died, whatever that was. But the exact range of the property did not need to be set out in advance, because the farm, all of it, or how many hectares? The House of Lords said this is different from Cobb against Yeoman's Row. On the basis in Cobb, there was no doubt about which property we're talking about, but it was unsure what benefit would be given to Cobb. Moreover, in Cobb, the relationship between them was a business one. They were dealing at arm's length. the parties did not enter into a contract, and they realised this was not legally binding. So the decision seems to prove it's much more difficult, but not impossible, to show an estoppel case in a business situation. But in a familial situation, it's more likely you can show that there's estoppel, because ordinary people don't know their legal rights. They're not used to dealing with property. So anyway, so Lord Scott made some intriguing remarks about remedial constructive trusts. Right, Henry and Henry is another leading case in this area. And there's so many cases in this area. So in Henry and Henry, the Privy Council heard an appeal from St. Lucia. This is proprietary estoppel. T purchased land from an old relative, G, just before G died. Now, G had promised to leave this land in her last will and testament to C, who lived on it and farmed it for 30 years. The trial judge said C's claim is no good. She hasn't suffered any detriment, and C has gained some benefit for 3 decades. T was a registered proprietor who'd given value for the land, and so that takes the land, and C's claim is defeated. The Court of Appeal said that C had suffered detriment and therefore had an equity and was binding on T as an overriding interest. This is from St. Lucia, which has got a privy land registration system, just the same as England and Wales. There was an appeal. T said that since she bought the land, it had not been unconscionable, she should not be bound by any equity in favour of C. The Privy Council found that the trial judge had misdirected himself about detriment because he hadn't considered C's disadvantages and the advantages coming from the promise. This is like Jennings and Rice. The Court of Appeal had been wrong in its attitude to detriment. Therefore, the Privy Council had to think about the issue anew, and they found that C had deprived himself of a more advantageous situation elsewhere by staying on the land, but that detriment had not been cancelled out by any advantages which accrued to him, because he'd worked very hard and it had been difficult to make ends meet when he occupied the land. So estoppel equity was satisfied. They gave C half of T's share of the plot. That's a quarter of the total. Proportionality is vital to proprietary estoppel. The Privy Council looked at the effect of estoppel equity on other parties. They said, ober dicta, there are cases where the situation of a third party might override a claimant's equity, and it had to be reanalysed, and the claimant might be found to have an equitable interest. So let's look at Suchit and Suchit 2012. Here Frank promised his son John that he would inherit the family farm and indeed the house there. But in his will, the testator, Frank, left everything to his daughter Caroline, giving her the power, though not the duty, to give the farm to John if she thought he was able to run it. Then Frank died. John wanted to enforce his lifetime promise and said this is proprietary estoppel. Now, at first instance, the court found that Frank had many times promised John unconditionally, and that he was going to inherit the farm, and this created a reasonable expectation in John's mind. But the vital issue here was a detrimental reliance. At various stages in Frank's life, John had helped his father on the farm and not been paid for it, but he was able to live there for free. And had some business expenses and had some sort of living expenses covered and business opportunities. But as the terms of Frank's will said, Frank did not think that John was capable of running the farm during his lifetime and had made other arrangements with the other farmers nearby. But at first instance, the judge found that John had depended on these assurances to his detriment, and John was therefore given the freehold of the farm and a house worth over £3 million. Caroline then appealed, and she said that the little work that John had done, bearing that in mind, this remedy was too much because John had suffered very little detriment, and this was more than necessary to do justice to him. Lord Justice Arden and the Court of Appeal looked at Lord Justice Walker's approach to proportionality back in Jennings and Rice, and they said that there didn't need to be a relationship between the relief and the amount of detriment sustained. What was needed was a determination of whether the award was out of all proportion or clearly wrong. Therefore, in these cases, the claimant's expectations were over the top with a detriment, and equity would be satisfied by doing something less drastic. So in Suchit, although the farmland and the house were valuable assets, their value was reflected in the unconditional assurances that the first instance judge had found Frank had given John. The Court of Appeal therefore upheld the decision of the first instance court. Toodaloo.